advice. Appealing the matter of Legal Services Ltd against Belsner.
Yes. My lords, I'm conscious of the time I've already taken up, so hopefully I can get done in no more than half an hour, even though that will exceed my allotted time in the timetable.
Right. Can you just give me 1 second?
Yes, of course.
While I sort of charge up my computer, otherwise you won't have my full and undivided attention.
Probably a good thing for me, from my point of view, I suspect.
I don't think so. Right, off you go. Thank you.
Well, I've been able to take some instructions on certain points overnight, and I'm going to relay those. I'm then going to tidy up from yesterday's submissions. I had the dubious pleasure of watching myself on YouTube, and I noted down what I had said I would do. It's not a good experience watching yourself. And then I'm going to make a return to the end of my fiduciary duty submissions and specifically to deal with Candy and Crumbler. And then I'm going to be very, very brief on the Consumer Rights Act, if I may. So far as the first of those concerned, the society on reform of the relevant provisions, the cost provisions in the 1974 Act, the Society doesn't have a formal position as to whether or not it should be amended. However, it is clear that there are concerns and it's aware that the Civil Justice Council is consulting on costs reform, and the Society is fully participating in that. It recognises that there are anomalies or problems with the current position in respect of those parts of the 74 Act which deal with costs, and provided any amendments are made carefully and cautiously, and overall an overview is taken, then the Society would welcome that. So far as the same goes for the position on contentious and non-contentious costs, again provided, if there is an amendment to that, provided that is done carefully and with a view to the overall position, then again the Society is content and will participate in any procedure leading up to amendment. I confirm my position as stated yesterday that it is the Society's view that provision of relevant costs information in writing is sufficient, provided what is set out is clear and legible and comprehensible. That should do in most circumstances, but if the client, of course, comes back, and the client should be invited to come back if they want to, then yes, any response should be made by the solicitor. And secondly, provided that if there is anything unusual on the facts which might alert the solicitor to the fact that the client might not be able to comprehend, or this might not be a circumstance where written information alone is appropriate, then the solicitor ought to provide more. So far as the relevant figures are concerned, I'm afraid the most up-to-date figures that we've got are those set out in Mr Dixon's witness statement. That's my instructions, the matters that which I sought instructions. Can I tidy up from yesterday? And I'll go in the order I think that they occurred when I was watching the video nasty. So far as the Ombudsman is concerned, that's Part 6 of the Legal Services Act 2007 deals with that. The SRA, I think, is set up under Section 31 of the Solicitors Act. And there is, of course, as I omitted to mention yesterday, there's the Solicitors Disciplinary Tribunal, which is the one that deals with breaches of the rules. That's specifically set up under Sections 46 to 55 of the Solicitors Act 1974. And that, of course, is, as the Master Rolls stated, that's the panel upon which he is appointed. He gets to appoint the Solicitors Disciplinary Tribunal. And I think as Lord Justice Nugee asked me about the disciplinary power, Section 47 deals with those.
What is the relationship between complaints to the Ombudsman and complaints of misconduct which goes to the disciplinary tribunal? Are they entirely separate?
They're entirely separate. I think Section 47A did deal with some sort of inadequate professional service, but I think that's been struck, that's been abolished now, and I think that you go to the Ombudsman. But I think they are distinct statutory bodies, because of course the Ombudsman deals with complaints which aren't necessarily breach of the SRA or the code.
They're consumer redress.
Yes. It can, and
there can be an overlap, obviously.
Yes, of course.
Yeah.
My learned junior, Mr Cohen, has, as promised, done a note which sets out the scope in respect of personal injuries and other claims in respect of now the small claims track and the fast track. It's an expansion of a note, most helpful note he provided to me. It's been agreed by all parties, and I hope that you will find that helpful. I know you're not exactly bereft of paperwork here, but I hope that that's a helpful note. So far as the Law Society CFA is concerned, the relevant passages and the clarity or lack of thereof, the relevant passages are in paragraphs 148 to 153 of Hollands and Russell, which is divider 56 of your authorities bundle. I was also reminded by Mr Williams that in the Herbert case, the CFA was also based on the Law Society model, and the Court of Appeal made certain comments about the clarity of that in that. If you look at paragraph 48 of the Herbert.
What did it say?
It said it was clear. It was complimentary about. I mean, it was dealing with all the paperwork, but the CFA there was based upon the Law Society model. And as I say, there was the appeal in Herbert failed, I think, on one very narrow point, but a lot of points were taken on the supposed lack of clarity of documentation, and those were dismissed. And if you look at paragraph 48 of Herbert, which is at divider 43. My Lord, I was making comments about the Herbert case, and perhaps irrelevantly, but as I made them, I'll just direct you to the passages that I was referring to without making any further comment. It was dealt, the point about how unusual or not the method of calculation of the success fee was originally made in paragraph 18 of our submissions, our original submissions to this court, which is Core Bundle 1, Divider 11, page 123. I referred to certain passages in Callery and Gray. That's in the Court of Appeal. It's paragraphs 80 to 83 in the judgment of Lord Justice Brooke. It's at divider 15.
What does that say?
That's the one that says some solicitors can assess success fees as insurers do by looking at their book. Some other solicitors can look at the facts of the individual case. Mm-hmm. It's an early indication of it. That's the point I was making yesterday.
Yeah.
And I referred to a passage in that judgment, and that is it.
What's the relevance of that to what we want to decide?
Little. It was part of my background, but as I made the point, I'm trying to skate because I direct you to. And finally, there's a paragraph. It's paragraph 2.4 of Lord Justice Jackson's final report, which is at divider 45. Mm-hmm. I was asked what the provision was dealing with CFA lights, and I think it's CPR 44.13. That's
CPR
44.13. I then dealt with what I was accused of making a jury point in respect of the business model of checkmylegalfees.com. And at one stage I mentioned disclosure and proceedings being initiated without seeing the relevant retainer documentation. I was getting that from paragraphs 10 and 11 of Mr Carlyle's witness statement in this court, which is at Supplementary Bundle 1, Divider 12, page 287. And it appears that in certain circumstances, Section 70 proceedings are issued without sight of the client's retainer documentation. There's one other point which I didn't make, but if you look at the respondent's skeleton, I think it's on appeal in respect of costs, which is at core bundle 1, divider 16, page 208. It appears that their position on costs is that even if there's no benefit to the client, i.e. the client gets no repayment on the costs, nevertheless, Section 7, the combination of Section 79 and 10 is that if there is a reduction in the bill, then costs are payable to the paying party, even though the actual paying party gets nothing in return. I achieve nothing. I mentioned the case that it's Mr Kirby to make his case, but as I mentioned it, I mentioned what was said against me, what should have been in the documentation. That's at I think it's paragraphs 143 and 144 of my learned friend Mr Kirby, Mr Dunn's skeleton argument, which is at Supplemental Bundle 1, 161 to 162. In respect of the delay, remember there was an interchange about the interplay between court proceedings and the ombudsman, and I eventually was prompted to refer you to Rule 5.7F, which is the one that says that the ombudsman can deal with matters if the court proceedings are stayed. I looked up also there's a time limit for complaints to the ombudsman. Rule 4.5, it's 6 years from the date of the act or omission about which complaint is made, or 3 years from the date the complainant could reasonably have discovered it. There is a power in Rule 4.7 to extend that time if, in quote, exceptional circumstances. And finally,
so in a normal situation, if somebody could reasonably have discovered the matter which they're complaining, they've got to bring a claim before the ombudsman or complaint before the ombudsman within 3 years.
3 years.
So it would actually be dealt with before the 6-year limitation period expired.
Yes, if
for the purposes of proceedings.
That's right. Well, if the complaint related to an act or omission which might be said to be in breach of contract or negligent, then yes.
Yeah. But not in relation to a taxation or assessment.
No. But then, of course, the 3-year and 6-year limit is much more generous than the limit under the.
The assessment has got to be done within a month of the bill.
That's right. Well, that you can extend that, but I think it's more or less 12 months. Okay. My little friend Mr Williams, who knows much more about these things than I, says it's more or less 12 months. But there are statutory time limits. But the point is the legal serviceman will entertain a complaint within 3 years. I haven't quite bottomed out what the interrelationship between the 6 years and the 3 years is, but it's Rule 4.5. But at least it's at the very least it's 3 years from the date of reasonable discovery. And finally, although the Chancellor mentioned cases where there could be liability can arise without or before a retainer, and you may have been referring to the Lejon Varm case, which is that was the architect who was found to be negligent. Although no retainer was entered into. We've got that at 65 in the bundles. It may have been that case. If it's a recent case where someone, I think, was a friend and gave their services for free, but was nevertheless held to be negligent when they fell out. But that's all I propose to say in tidying up, that's my phrase, from yesterday. I would like finally to deal with final point on fiduciary duties by looking at Candy and Crumpler, if I may. I don't know
This
whether...
may or may not be good law, right?
Exactly. I'm hoping it is, but then I was for the respondent. But it's good law for the moment. This is a case to do with the waiver of the Solicitors Lien. My Lord Justice Nugee may remember he dealt with...
Solent.
So that's right, you dealt with Solent number 2, indeed. Passages from your judgment were quoted with approval in the Court of Appeal, and no one dissented in the Supreme Court. But the nature of the Solicitors Lien is set out in paragraph 30 of the judgment of Lady Justice Rose, which in turn quotes from Edmondson and Haven Insurance. A solicitor's lien is a form of equitable charge which allows the solicitor to keep the proceeds of any litigation to discharge his or her fees. And that's the scope. It's an equitable charge. It's similar in concept to the unpaid vendor's lien and indeed the purchaser's lien. And it's now recognised in statute by Section 73 of the Solicitors Act, which is quoted at paragraph 34. And the point, the relevance of all this is that, of course, as any lien, it can be waived, but there is a string of authorities dating back to the 19th century in which the courts have held that it's easier for a solicitor to waive his lien than it is for other people. If you enter into an arrangement with your client which is inconsistent with the retention of the lien, then unless it is expressly preserved, it is deemed to be waived. And the reasoning behind that is said to be the fiduciary relationship between the solicitor and his client. And one of the leading cases, if you go to paragraph 36 of this judgment, you will see Lady Justice Rose quotes from Reed Taylor, Stylman and Underwood. And if you look at the passage from Lord Justice Lindsay's judgment, which she quotes at the bottom of paragraph 36, it's quite well known, but you will see the point. Can I invite you to read the court to read that?
It's the solicitor's duty to explain what he's about to do.
That's right. Now,
I would have thought that was fairly uncontentious.
yes, but the point is this, and there are other passages in that way. The point is, it might be said, you see, against my position, that, well, if a solicitor has a fiduciary duty, or as part of his fiduciary duty, a solicitor has a duty to explain to his client the effect of what he's about to do, why doesn't that apply to his negotiations in relation to his initial retainer? That's, it seemed to me that one needed to consider that. And indeed, if one looks at the passage quoted from the judgment of Lord Justice Kay in that case at 38, you could perhaps draw a similar conclusion.
38.
So paragraph 38 of Candy and Crumpler, which is an extract from the judgment of Lord Justice Kay in that Reed Taylor Stylman case.
To represent to his client all the facts of a case in a clear and intelligible manner to inform him of his rights and liabilities.
That's right. Now, taken in isolation, you could say, aha, well, if why doesn't that apply by analogy when you are looking at the position of a solicitor negotiating his initial retainer with the client? Now, I know my Lord Justice Nugee is not keen on the temporal distinction, but it's clear what we're dealing with here, what these cases are dealing with, are circumstances where there is a pre-existing relationship which derives to fiduciary duties, and the solicitor wants to change that relationship. relationship to alter the rights and obligations between the parties. Now, so it might be said, well, the case is different because when one's dealing with the initial negotiation, it's not the same thing. But in my submission, that wouldn't be a good submission, because if you look at how Lady Justice Rose justifies all of this, my Lord, if Lord Justice Nugee, his decision is quoted paragraphs 42, 43 and 44 of the judgment. But if you look at paragraph 56, you will see how Lady Justice Rose explains what's going on in these situations.
Yeah.
My submission would be...
It's a completely different situation.
Exactly, but if there is a duty to explain, it's not a general duty to explain what's the nature and effect of any contractual document or any arrangement pursuant to a fiduciary duty. It's a duty to explain in relation to the security, the effect on the security which the solicitor already has of any new arrangement.
I mean, it's a complete misunderstanding of what the fiduciary duty is. The fiduciary duty is a duty of loyalty.
Yeah.
And the only fully informed consent part of it is to give fully informed consent to the solicitor taking a benefit.
Yes.
Right? So if it's going to be fully informed consent to the solicitor taking a benefit here, it's fully informed consent to the solicitor being paid the amount he's negotiated.
Yes. Well, my Lord, I accept that. I was only dealing with that case lest it be said against me that it gave rise to or exemplified...
I think you're being overcautious, but we'll see what Mr Kirby has to say.
I'm grateful. Can I then very briefly deal with the Consumer Rights Act?
Yeah.
We accept, the Society accepts the Consumer Rights Act can apply in principle. But secondly, as the court said yesterday, if Section 74(3) doesn't apply, then the Consumer Rights Act is irrelevant because the prejudice said to arise, the unfairness said to arise, is the exclusion of the Section 74(3) right. Thirdly, the Society would submit, and we have submitted, that it falls within the exclusion of Section 64(1)(b).
Sorry?
Exclusion of?
It's Section 64(1)(b). I think the core terms exclusion, I don't know.
Oh, 64(1).
Yes.
The core terms.
Yes, it deals with the price. And my Lord the Master of the Rolls quoted paragraph 170 of the Respondent's skeleton yesterday. And if one analyses that, what is said is, well, the effect of this is you can charge us more than you would otherwise be able to do so. And that's a term as to the price, and we say, therefore, it's excluded. Fourthly, we submit that, as both myself and Mr Williams have submitted at length, that the solicitor is never entitled to charge more than reasonable fees under this regime. And it's difficult, we would submit, to see how a regime which allows the solicitor to charge no more than reasonable fees reasonably incurred is in any way unfair under the statutory definition. And I went through yesterday the various avenues of redress open to the client. And finally, the point I got back to at the start, it's difficult to see, given that each of these cases depends very much on its own facts. It's difficult to see how any sort of challenge, even if otherwise jurisdictionally appropriate, could get off the ground in the absence of any evidence from the client.
The same contract could be unfair in relation to an unsophisticated client, but perfectly fair in relation to a highly sophisticated client who had in fact read and understood every word of the contract.
Yes. These are, as I understand it, I'm not an expert in this field by any means, but as I understand it, these are fact-specific decisions, albeit that the NatWest Bank one was, I think, a general one about, wasn't that, overdraft charges.
Certainly was. I spent a year of my life on it.
I'm sorry for my lord, but...
But is that right? I mean, if the term could be unfair for everybody, couldn't it?
I suppose that's right. I suppose you could say, well, regardless, even if it is, even if Ms Belsner was a professor of law or a Lord Justice of Appeal, nevertheless, that term would be unfair.
Which part of the legislation asks you to look subjectively at the person, the consumer? I don't remember that.
I think it says all the circumstances. I'll dig it out. Give me.
I'll go through materials.
Oh no, so that's the authorities. Forgive me. Yes, it's 62.5, I think, isn't it? Whether terms of affairs to be determined, A, taking into account the nature of the subject matter of the contract, and B, by reference to all the circumstances existing when the term was agreed and to all the other terms of the contract or of any other contract on which it depends. I've assumed that it would involve, in most cases, a consideration of the circumstances in which the contract was entered into, and therefore would involve an examination of the nature of the person who entered into the
Well, I mean, it might, but I mean, it also might not. I mean, it might be that the term is so unfair that it doesn't matter what the circumstances were. I don't see it's a knockout point that she hasn't given any evidence. I mean, obviously it'll be assumed against her that she's a sophisticated consumer. She's still a consumer.
Yes. And there's no
consumers are consumers.
Yes. Well, my lord, I've made that point.
Okay.
All right. You'd be glad to hear that unless you have any further questions, those are my submissions.
No,
Anything else?
Can you just tell me, I'm just looking at this act, the Consumer Rights Act.
Yes.
Schedule 2,
Yes.
which is at page 75 of the bundle.
Yes.
A list of terms which may be regarded as unfair.
Yes.
And it's tied to section 63. We don't seem to have section 63. Do you know what it says?
No, not off the top of my head. I can get it for you, my lord. But that's a list of indicative conditions which are said, these are the types of terms.
Yes, but none of those are depending on the sophistication of the consumer. They're just things which may be unfair, such as enabling a trader to terminate a contract without notice, that sort of thing.
I mean, I agree.
It can't, in the end, depend upon whether the consumer has read it and understood it. If it's an unfair term, the fact you've signed up to it doesn't stop it from being unfair.
Well, it depends on the term.
Depends on the term.
I accept that if you get, look at 2, a term which has the object or effect of inappropriately excluding or limiting the legal rights of the consumer in relation to the trader, if you get something like that, then yes, it doesn't matter how sophisticated the consumer. But those are just indicative. I mean, the only point I would make is that none of those are anything like the current situation at all.
No, and according to 63.1, FYI, it says Part 1 of Schedule 2 contains an indicative and non-exhaustive list of terms of consumer contracts that may be regarded as unfair, and Part 1 of Schedule 2 may nevertheless be assessed for fairness under Section 62 unless 64 or 67. I don't think you need one about that.
No.
I'm great.
Thank you.
I'm great.
Right. Mr Kirby.
Hello. My Lord, I recall my Lord the Master of the Rolls' comment at the end of yesterday, but I'm afraid I'm not promising to finish by 4:30. But I will do whatever I can.
Disappointing, but we'll live with that disappointment.
Well,
Yeah.
if that's the only disappointment, my Lord, I'd be very happy. Let's move on. My Lord, I want to very briefly say, make a few comments about what this case is about and what it's not about. I then want to very briefly, because my Lords have been addressed on it at length, highlight a few of the facts. And my Lord, I will then go through the agreed list of issues in the order in which they appear in the agreed list of issues. So that will be dealing, first of all, with whether on the proper construction of Section 74(3)(a, whether the protocol constitutes contentious business. I will then go on to deal with whether there are proceedings in the county court, and then the issue after that will be whether the fixed, and this will be a very brief point, whether fixed costs limit the amount which may be allowed. I will then go on to deal with the consequences and whether there is a written agreement for the purposes of 4692. I will then go on to deal with what are the consequences if this court finds that it's non-contentious business and what this court should then do about that. I will obviously, within that, be dealing with the question of within these topics, be dealing with the question of fiduciary duty. And I will conclude, as my learned friends have, also with the Consumer Rights Act. So, my Lord, first of all, this case is not about the reasonableness of solicitors' costs, because solicitors' costs are always subject to assessment. This case is about whether the fetter, the consumer protection fetter of Section 74(3), applies, and if it doesn't apply, and these are non-contentious costs, whether notwithstanding the reasonableness, what might otherwise be regarded as the reasonableness of the costs, whether or not they are fair or not. I would say in opening...
Hang on, I think I need to unpack that. Whether, notwithstanding the reasonableness of the costs, they are nevertheless fair.
They are nevertheless unfair. Forgive me.
They are nevertheless unfair.
Because?
Now, why? Why is that the issue?
Because if these, were this court to find that these are that this is non-contentious business, then the costs have to be assessed.
Yeah, but we're not being asked to assess whether they're fair or not. Nobody's ever appealed on that point.
Well, forgive me, my Lord, but my Lord, on the last occasion, my Lord the Master Rolls on the last occasion, indicated that, and I realise the constitution of the courts has changed apart from anything else, as well as certain indications. My Lord the Master Rolls on the last... Sorry, forgive me?
Mr Kirby, life unfortunately changes.
It does.
Circumstances change.
Comes at you head on sometimes. My Lord, my Lord on the last occasion indicated that whatever this court's finding, that this court would then deal with the matter.
Deal with
my notice of the assessment of the cost, which at the time I thought was a little surprising.
If you're wrong about Section 74(3),
yes,
and it doesn't apply because this is non-contentious business, or for that matter, if you're wrong about CPR 46.9,
yes,
then the only issue is that there would be an issue on assessment as to the reasonableness of the costs. But if the cost judges assess them and held that they're reasonable, end of point, isn't it?
Well, because
they can't be unfair under the Consumer Rights Act. I mean, that was the point that's been made against you by both your opponents, or by your opponent and by the intervener, is that if you're outside the Section 74(3), your case on the Consumer Rights Act must fall away.
Well, I realise that's the case made against me, and I will deal with that in due course. But so far as any finding that these costs are in relation to non-contentious business, they are assessed on a different basis. So instead of just being reasonable, they have to be fair.
But they've been assessed.
Yes, but they haven't been assessed under as non-contentious costs, as non-contentious business costs. They've been assessed as contentious business costs.
Have you got a respondent's cross appeal on that point?
Not on that point. My Lord, until this court, and this is Mr Kirby bellyaching again, to use my friend's phrase, until this court, there had been no suggestion that this was non-contentious business.
But I mean,
the suggestion before the district judge had been that there were no proceedings and that therefore Section 74(3) did not bite, not that these were non-contentious costs.
no, but you knew that they had amended their notice of appeal to put in grounds 7, 8 and 9, which claim that the judge had been wrong about Section 74(3), right? Or the assumption that he'd based his decision on was wrong. And you didn't put in a respondent's notice saying these costs, the assessment of the judge would have been different. I mean, I was going to ask you about this. In fact, I was going to ask Mr. Williams about it, but I forgot. About what the effect of various outcomes of this appeal is. But let's take my Lord's position. You lose on Section 74(3), and these are and always have been non-contentious costs. My understanding of everybody's submissions up to now was that the assessment of non-contentious and contentious costs has always been regarded as the same thing. That reasonable, that fair doesn't really add much to reasonable. So although it's different, it's probably the exercise would be the same, and certainly would be the same in this case. Now, we're not going to say it's always the same, that would be ridiculous, but it seems to me a philosophical question whether fair adds anything to reasonableness, and rather an interesting one, actually. I was thinking about it last night because reasonable is probably more objective than fair, but whether that really makes a difference, save to a philosopher, I don't know. But the point is, you've never put in a respondent's notice saying, if I lose on Section 74(3), I want to query Mr Justice Lavender's view about what was the assessment, which was whatever he decided in relation to the success fee and so on. And so I assumed that if the appeal is allowed on Section 74(3), and you don't succeed, if the appeal is allowed in Section 74(3) and on the fiduciary duty point, and you don't succeed on the CRA, that Mr Justice Lavender's order would stand. Is that wrong?
Well, my Lord, we would say that that is wrong because the costs were assessed by the district judge. They were assessed by the district judge as costs in relation to contentious business. The appeal to Mr Justice Lavender was not on the basis that these were non-contentious business costs. The appeal to Mr Justice Lavender was on the basis that there was a written agreement for the purposes, insofar as 74.3 applied, there was a written agreement which excluded reliance on 74.3.
But the district judge held, didn't he, that the solicitors could in fact have charged in terms of hourly rates. They could have charged £120 an hour, which is more than they charged. And unless you could say, for some reason, which at the moment I can't see, that if these had been assessed as non-contentious costs, his decision would arguably have been different, and he would have said, well, actually, they can only recover £25 an hour. Then it's a non-point, isn't it? Well, because what's said against you is, well, if Ms Justice Lavender was wrong, for all the reasons that Mr Williams says he was wrong, then in terms of the assessment, these costs are reasonable or are fair and reasonable, and therefore they're entitled to recover what they seek to recover.
Sorry, I misspoke, I think.
Yeah, I think you did. Yeah.
What we would do if we allow the appeal is simply give them back the £345.
Yeah, whatever it was. Yeah.
Sorry.
But it's just not. I mean, there isn't an issue before this court that if these were non-contentious costs, the district judge got the assessment wrong.
It would not be a question of suggesting that the district judge, having allowed £100 an hour, should only have allowed £50 an hour. That simply goes to reasonableness. The question would be whether it is fair when the client is told that they will recover all or part of their costs, where they are told that they will recover at least a substantial part of their costs, whereas in fact at the time the solicitor knew or should have known that if it settled at the stage that the solicitor expected it to settle at, that they would only recover 20% of their costs, of their estimated costs. So if the client is told you will recover all or part of your costs, you will cover a substantial part of your costs, then is it fair, and I'll come back to another case in a moment, is it fair on a non-contentious cost assessment that the solicitor can get their reasonable costs because they reasonably spent X hours doing the work, when in fact they've said to the client, you'll recover most of your costs from the other side?
But that's not what's happened.
Mm-hmm.
Well, it's not what's happened thanks to the whim or the decision of the solicitors at the end of the matter. That was then in their gift. My Lord has referred to the contract, and those of us who have done or do some commercial work look at contracts. Well, the contract, under the contract, the solicitor was entitled to some £4,000.
Yes, but he hasn't claimed it.
Well, he hasn't claimed it, but he was entitled to it. So when the contract was entered into, when the ink was dry on the contract, at that particular point, and indeed at the end of the case, the solicitor could have said,
Yeah.
I'll have £4,000, please.
But you may rest assured that I am now saying that is wholly unsatisfactory, that it should be in the whim of the solicitor. But Mr Williams has assured me that that is not current practice, and that I think he used a word about they wouldn't dream, solicitors would not dream of charging. They would always cap their bill at the kind of level we're talking about.
Well, Mr Williams did say that, but with respect, they didn't actually put any evidence before the court about this particular firm of solicitors or what the solicitors were doing generally. The evidence before the court put in by Mr Carlyle goes through some 900 odd retainers and analyses them by reference to whether proper explanations were given, whether they were CFA lights, whether they were unlimited CFAs, or whether they were capped CFAs. and there is a range of those.
No, but no evidence tells us whether Mr. Williams is wrong, or suggests that Mr. Williams is wrong to say that no solicitor would dream of charging the client £2,500 when they recovered a few hundred.
Well,
And if that was the intention of the solicitors from the outset, which I think is Mr. Williams' case, despite what was said in the contract, why isn't that one of the circumstances existing when the term was agreed, which the court can take into account in assessing whether it's fair and reasonable or not? Even assuming it in your favour that you're not caught by the core exclusion in section 64.
Well, my lord, if...
I mean, you're asking the court to decide on this basis that the term is not fair, or not fair and reasonable in circumstances where your client hasn't actually, because of what happened, your client hasn't actually suffered any detriment whatsoever, other than conceivably whatever it is that this court might order to be paid back, £370.
Well, my lord, obviously I accept that the amount of money involved in this case, and here we are on day 4, in effect, of taking time up in the Court of Appeal, that the amount of money involved in this case is very small. Although I have to say we're somewhat taken aback by the criticisms made on behalf of the Law Society and by my own friend Mr. Williams with regard to these particular cases. I mean, the Law Societies look at Edmondson, look at Bott. Those were all cases of very small amounts of money, but the Law Society was quite content to intervene in those cases.
Well, let's not get into that, because it's just going to inflame people's temperatures, but or elevate their temperatures. What I'm concerned about is the use of the word fair in 2 different and quite different contexts, and the elision of that. Now, the first question that is in issue in this case is a term of the contract unfair under the Consumer Rights Act, right? You can argue that.
Yes.
Right? Yeah, of course. The second question is whether it's fair and reasonable for the purpose of an assessment under CPR Part 46.9, or whatever it is. Mr. Holland is telling me it's not that, but anyway, whether it's fair and reasonable as non-contentious costs if you lose 0.1 on an assessment. I see nothing in the papers here that tells me that it is this court, we were being asked to do more than if we allow the appeal against Lavender J to reinstate the district judge's assessment.
Well, my lord, it's certainly, and I'll ask my learned junior in order to save time to find the relevant passage for me. But
The relevant passage of what?
if I could
said
just forget-
something incautious, but that doesn't affect.
If I could just forgive me, my lord. The relevant passage in our skeleton argument.
Oh, okay.
Sorry,
Whether
you let
it's
me
in the
finish the
skeleton
sentence.
argument or not, it's not an issue in the case, is the point that my lord's putting to you. Where is it in the list of issues? Let's have a look at the list of issues, agreed list of issues. I mean, we've been around the houses, as you rightly admitted a moment ago, twice now.
Well, my
And
lord,
to have
the
you
list
stand up on day 6 or whatever it is and say, well, I want to argue this point, certainly for my part, doesn't delight me, shall we say.
my lord, issue 5 in the list of issues.
Where is the list of issues?
The list of issues is in the supplementary bundle, volume 1. I think it's page 3.
Thank you.
Right. If what you're arguing is that entitles you to unravel the district judge's assessment, for my part, I don't accept that. And I don't think my lords do either.
I mean, how can it, what are the consequences is simply, I mean, where is it in your skeleton? Let's have a look at that. By the way, just for future reference, whilst we're having this interesting debate, issues like what are the consequences are to be avoided. It's very important to tell the court precisely what they're being asked to decide. So it's only because I didn't have time to look at this and rectify it that you've been allowed to get away with that as an agreed issue. It's completely unhelpful and has now led to this unnecessary discourse.
Well, point taken.
Yes, okay.
Right,
Just
so
for future reference.
issue 5.
Issue 5 is on page, in the bundle, it's page 166 of the supplementary bundle.
No, I need your
167.
I need the reference to your skeleton
Yes,
specifically.
that is the reference to the skeleton.
So which paragraph?
Starting at paragraph 165.
I don't understand that raises the issue that you're talking about. The court would consider. I mean, you haven't said the district judge was wrong to find as he did, and he should have found this or that. Have you?
Well, obviously, I don't say the district judge was wrong.
You don't.
No,
What
because
do
the
you-
district judge assessed the costs with reference.
No, say you do not say. Come on now, Mr. Kirby.
Sorry,
No,
if-
you do not say that if the district judge had assessed on the basis of fair and reasonable rather than reasonable, he would have found X.
No, I accept that.
Shouldn't you have said that if you wanted that to be argued? I mean, does Mr. Williams know that this is what we're all going to be doing? We're going to be assessing this bill of costs on a fair and reasonable instead of reasonable basis.
I don't know. Because
Let's ask him. Mr. Williams, did you know that?
I do remember, I haven't looked back at the transcript, I do remember something being said the last time that if possible remission would be avoided, and I think at that stage you talked about possibly sitting with the senior cost judge.
Yeah, we did.
That might be what we missed, but I have to say, once I got Mr. Kirby's skeleton, and Mr. Kirby's skeleton did not say, and the consequences would be that the district judge would have come to a radically different figure because there would have been a fairness criterion and the following things would have been found to be unfair. You know, that I certainly wasn't expecting. That's the point that
precisely the point.
Precisely. So
See,
that's
what
the
I'm
position.
worried about, thank you. What I'm worried about is that, I mean, I'm not accusing you of anything, but you seem to be saying, well, if I can't get home on the CRA, I can feed everything that I hang on the word fair from the CRA into the assessment and reopen the whole caboodle. And it seems to me that if you wanted to say that, you have to actually say that fair equals the same as in the CRA. Fair in the legislation for assessment of non-contentious costs equals feeding in the entire caboodle of the CRA.
And
It seems incredibly unlikely. But
and go on to say that through no fault of his own, the district judge was wrong.
yes,
You'd have to go
although
that
that might be. I mean, I'm not
Well,
taking
that's
issue, but it might be a little unfair to the district judge because he thought he was assessing
Well, I agree.
contentious
I agree.
costs.
Or adopted the wrong approach.
I mean, I get very confused because District Judge Bellamy, whom God preserve, has retired District Judge Bellamy, has, in the two cases we're dealing with, dealt with, I think, 4 hearings, and I'm not sure that it's not 2 all on the subject of whether 4.3 was applied or didn't apply. But I think it would be fair to say to him that he didn't think it made any difference to the assessment.
Well,
Indeed, Lavender J said that.
my lord, I think that's in the Carriage matter.
It may well be.
Yes.
I mean, I'm afraid they do merge.
Well, I understand, and I can't pretend to be ignorant of the Carriage matter because I was appeared in the court below, not appearing in this court. My Lord,
So you're not appearing. You're not appearing in causation.
no,
Mr. Dunstan.
Mr. Dunstan.
Oh,
You'll be relieved to know, yes. My Lord, I'm going to take on board. I'm not going to.
no, we'll think about it overnight.
Can I think about it overnight? I think where I may want to come back to it, I take on board comments made by my Lord the Chancellor. I will come back to it and I will consider whether to raise it at all further when I deal with the Consumer Rights Act.
Yeah, okay.
Because that is, at this rate, going to be tomorrow, not today. Well, I am conscious of the fact that you have been taken through the retainer on a number of occasions. And so, to save time, unless my Lord wishes me to take you to the particular pages, I will simply give the page references.
We don't even need that, do we? We've got your skeleton.
My Lord, I do wish to make certain points with regard to it.
Oh, yes, you make the points.
My Lord, the CFA was signed on the 18th of March 2016. That's reference core bundle divider 46, page 447. Ms Belsner had been a client for at least 11 days prior to that, because on the 7th of March, the solicitors signed a claims notification form and submitted that onto the portal. And in submitting that onto the portal, they would have to have signed a statement of truth. And that statement of truth, there isn't, in fact, I don't think, a standard CNF in the bundle, but the statement of truth on the CNF says as follows: I am the claimant's legal representative. The claimant believes that the facts stated in this claim form are true. I am duly authorised by the claimant to sign this statement. So prior to the signing of the CFA, Ms Belsner had expressly assented to CAM acting on her behalf, and CAM had assented so to act.
I think all that's common ground, right?
That's common ground, but the significance of it, obviously, my Lord, is that we say the relationship of agency and the relationship of solicitor and client starts no later than the 7th of March 2016.
That is also common ground.
Yes, but so that is 11 days, and this will be common ground because it's just maths, so 11 days before the CFA is signed.
Yeah, I mean, it's also common ground, I imagine, that in relation to anything they did on the portal on her behalf, they owed her fiduciary duties.
Well, my Lord, we would say that they, and I was going to deal with fiduciary duties much later in my submissions, but we will say that fiduciary duties are owed to her from the moment that they become her solicitors. And that's probably not going to be in dispute either. No. The question is, what are those fiduciary duties and whether there is a breach of them. But I'm going to deal with that in due course, unless my Lord would.
Right, so why are you emphasising this now as a sort of a totemic point?
Because I am wanting to, perhaps there was no need because it's common ground, as my Lord's just pointed out. I was wanting to make clear that this is not a case where you're dealing with retainer documents on day one.
No.
And therefore you've got Mr. Blogg sitting opposite you and you're going through the retainer documents and you're negotiating them. This is a case where you've got a client who you've acted for a number of days, and then you send to them perhaps that same day, but they don't actually sign up to anything until 11 days later. And so there is a period of time during which those fiduciary duties are owed.
Can I just check? It's common ground that when the solicitors put the material on the portal, they are acting as the client's solicitor. They're acting as the client's agent.
Yes.
Is it common ground that at that stage they have a contractual retainer? Are they? Sorry. Has there been a contract, or because you could act as someone's solicitor without a contract? It seems to me.
My lord, so far as these solicitors are concerned, they've certainly charged for the work done between that date and the date of the CFA.
But would they have been entitled to charge if the client had said, before signing anything, actually I've changed my mind? Guess what?
Well, my lord, in our submission, they would have been entitled to charge on the base a reasonable sum for the work done on the basis of an oral.
That must be on the basis that there is a contract of retainer.
Well, there's an agreement. There's agreement to act,
Yeah.
and so there would have to be some retainer at that stage.
Okay.
There's an oral retainer.
Yeah.
Forgive me, my lord.
There's an oral retainer or an informal retainer of some description.
Well, my lord will have to help me as to the difference between oral and
Well,
informal.
I don't know.
But
I can't remember now whether there was a discussion between them or not. But otherwise, your clients would be being officious interveners. They might not be entitled to anything. Sorry, you're saying from Mr. Williams's clients. They must have had.
Well, your case is they were retained, one or the other.
They're retained.
Yeah.
And that gave rise to contractual rights and obligations.
Absolutely. My lord, the sequence of, in fact, I think my friend Mr. Williams took the court to the sequence of the correspondence is there. You don't need to see it, but you will see what was actually the attendance note of what was said on the
It's really a no-brainer that they were solicitors acting pursuant, as my lord says, to an oral retainer from the 7th of March.
Yes.
Yeah.
And there was that was then crystallised into a CFA on the 18th of March.
Indeed. My lord, can I move on to deal with the question of contentious business?
Yes.
My lord, that is defined, as you know, been taken to the definition in section 87. My lord, section 87 is prefaced with the words, unless the context otherwise requires. 87 being the definition section.
Yeah.
And
I mean, this is a lot to put on those words.
well, it may be, but I will take you to other sections which you haven't been taken to, which may assist.
Okay.
My Lord the Master Rolls observed on the last time, but life changes as we know, that it was perhaps absurd or indeed lacking in common sense that such matters could be described as non-contentious.
But it's common ground that it's lacking in common sense and absurd.
Well, I think it. Well, I'm not sure that is common ground. I'm not sure.
Pretty common ground. I mean,
I think it's common ground. It's anomalous.
But what is anomalous? Let's use less inflammatory language. Anomalous because life has moved on. So employment proceedings are really litigation, and they're regarded as non-contentious business. Portal proceedings are really litigation, but they're regarded as non-contentious if the definition is given its full literal effect. But that's because of changes of circumstances. In 1974, no doubt this definition was fine.
Well, I agree. And of course, when we come on to consider, or when I come on to make our submissions with regard to updating construction, obviously one of the points that we make is that in 1974, a system of computerized portal for resolving disputes could not possibly have been envisaged because one didn't have, you just about had a computer, but you certainly didn't have, for instance, the internet.
Does that matter? I mean, what could have been envisaged in 1974, and indeed was envisaged by Mr Justice Wynne Parry in 1950-something, was that you could instruct counsel to advise on proceedings, and you could draft proceedings, and you could send a letter to the other side, and the matter would settle before a writ was issued. That was non-contentious business. What's the difference between using that and using a portal?
Well, I am going to take my lord to the decision of Mr Justice Wynne Parry. In that decision, the judge was not taken to a decision of I think it was at that stage Lord Justice Denny, in Rea Solicitor, and was not taken to the forerunner of Section 61 of the Solicitors Act with regard to contentious business agreements.
So you want to tell us that he was wrong?
Mr Justice Wynne Parry, yes.
In which case, it's not a question of an updating construction. It's that it always was wrong to regard these things as non-contentious if proceedings weren't issued.
The earlier decision of the Court of Appeal was on different statute and different wording.
It was on a different statute, different wording. Mr Justice Wynne Parry then said that there was a narrower wording in the earlier Act, and that the Act he was considering
Well,
was...
it may be narrower in one way and wider in another.
Anyway, you make
Sorry,
your...
I've slightly interrupted you.
You make your argument. I think that's going to be quicker.
Agreed.
Well, Lord, I wonder if I can take you to the Solicitors Act. I think that's where we ought to start.
That is a good place to start.
My Lord, that's in the statutory materials. It starts on page 4 in that bundle.
Mm-hmm.
I don't think I need to take the court to the definition of contentious business. You've seen it several times. It's on page 31 of the bundle. The start of section 87 appears on page 30, which is where the words "except where the context otherwise requires" applies. If we go back to page 4, there's a section with regard to orders as to remuneration for non-contentious business, and that's to do with the making of orders with regard to the assessment of non-contentious business. But if you can then go over to page 7, on there has a section that deals with non-contentious business agreements. And then when you go over to 59, page 8, you have contentious business agreements.
In a section headed contentious business.
It's
which is very significantly longer than the section headed non-contentious business. Interesting.
Sorry, give me a moment.
The section headed contentious business.
Oh, in the definitions?
No. It's on your page 8.
Yes.
Just before section 59.
Mm-hmm.
It's headed contentious business.
Yes.
And that proceeds, I think, until section 68 or something.
Yes.
Whereas there are only 3 sections under
dealing
the
with
heading
non-contentious.
non-contentious business.
Forgive me, I didn't realise my lord was referring to the number of sections in the...
Well, it's quite interesting. The point is that you have to look at the Act. The reason why this bundle is so unhelpful, and I said this last time, but nobody took any notice, not that I'm complaining, is that Part 3 of the Solicitors Act needs to be read as a whole. And you can't understand what it's saying unless you look at the entirety of Part 3 and every section in it, I'm afraid. And this has only got some of them.
Right.
But, I mean, you will take your own course. You all have.
And we'll probably continue to do so, but try and take on board what's been said.
Yeah, it is quite important, actually. With any legislation, if you're looking at what the legislation, particularly if you're arguing for updating construction, you do need to see the thing as a whole, because otherwise you don't understand Parliament's intention as to what it was seeking to achieve. Anyway, I mean, you carry on, but I do think actually all the sections are quite important. Yeah.
Well, I was then going to section 61.
Yes.
So this is to do with enforcement of contentious business agreements. I don't think we've looked at it before. And you'll see from subsection 1 that no action shall be brought on a CBA, but on the application of any person who is a party, as alleged to be liable to pay, the court may enforce or set aside the agreement. Subsection 3 this is referring to as business done by a contentious business agreement as business done or to be done in any action. A client who is a party to the agreement may make application to a cost officer of the court for the agreement to be examined. Subsection 6 deals with the court, and one can see that
Sorry, this is subsection 6.
Subsection 6. The court means in relation to an agreement under which any business has been done in any court having jurisdiction to enforce and set aside agreements, any such court in which any of that business has been done. Little b, in relation to an agreement under which no business has been done in any such court, under which more than £50 is payable, the High Court. In relation to an agreement under which no business has been done in any such court, under which not more than £50 is payable, the County Court.
Unamended.
Forgive me?
£50 unamended.
£50 unamended, yes. Well,
Would ridiculous be...
that would be a perfectly adequate word for £50 because I can't imagine any solicitor's bill ever comes out at under £50.
Yeah.
But, my lord, that is obviously not the point that I'm seeking to draw from the subsection. The point that I'm seeking to draw from the subsection is that you can have a contentious business agreement in relation to business where no court proceedings are ever issued.
Is that what it says?
Well, it says in relation to an agreement under which no business has been done in any such court.
Such court is a reference back to court in 6A, which is any court having jurisdiction to enforce and set aside agreements. Suppose you went to the Magistrates' Court, which doesn't generally have jurisdiction to enforce and set aside agreements. You might say that that was an agreement in which no business had been done in any such court. It would still be court business, wouldn't it?
Well, it goes on to say that in paragraph A, court having jurisdiction to enforce and set aside agreements includes the county court. I mean, I take the point that my lord makes, but I really do question whether that's likely to be the proper construction of the clause when it's talking about
Okay, let me give another example.
Yes, of course.
The definition of contentious business includes business done before an arbitrator. So you could have an arbitration contentious business agreement in which no business was done in any court of any sort.
My lord, you could. The earlier version of this section did not, within the definitions, have arbitrator, and yet had the same provision with regard to before a court.
I mean, I just don't understand the point you're making at all.
Well, the point that I'm making is that you can have contentious business with the same definition of the same definition applying to all of the sections in this part. You can have a contentious business agreement with regard to business when there are no proceedings ever issued in a court.
Well, where does it say that?
Because at subsection 6, where you are seeking to enforce a contentious business agreement, you can, in relation to an agreement under which no business has been done in any such court, so in either the High Court or the County Court, and under which more than £50 is payable, you can go to the High Court to enforce it.
Well, okay. I'll have to look at it. I'm afraid it's quite a tortuous subsection. But in relation, the court means in relation to an agreement under which business has been done in a court having jurisdiction to enforce and set aside agreements. So, where business has been done in a court which has jurisdiction to enforce and set aside agreements. Court means that court.
Yes, so if you've had proceedings in the High Court or in the County Court.
In relation to an agreement under which business has not been done in that kind of court, but possibly in another court, the High Court. Why does that say anything about contentious?
Any such court is a reference back to any court having jurisdiction to enforce a set-aside agreement. So if hypothetically the business has been done in a court which doesn't have jurisdiction to enforce and set aside agreements, then subsection 6b would apply, but it doesn't follow from that it's covering situations where no business has been done in any court at all. It just doesn't follow.
Well, my lord, perhaps it's helpful.
But is this a contentious business agreement within the meaning of the statute?
Very good question, my lord. If my lord is asking about the CFA in this case, my lord...
Is it? I thought it wasn't.
Well, my lord, I didn't say it was. My lord, it is said not to be a contentious business agreement. But my understanding is that the reason why it is said not to be a contentious business agreement is in order to preserve the client's rights to have the bill assessed without it being regarded as a contentious business agreement.
Well, that's the whole point, isn't it? Because section 60, or section 59, talks about the solicitor being remunerated by a gross sum. In other words, a contentious business agreement is one under which there is no assessment. So you make a contentious business agreement. I will pursue these proceedings for you in X court, and you will pay me £2,000. That's a contentious business agreement. This is not a contentious business agreement because it was never intended that there would not be an assessment of the costs. Have I misunderstood that, Mr. Williams? But I thought that was
not at all, my lord, because I agree with that. But this was an agreement for contentious business.
Well, that's a different point, with respect. You say it was an agreement for contentious business, but it's not a contentious business agreement within the meaning of the statute.
I don't think Mr Kirby realised that you actually addressed a question to me a few moments ago.
Yeah, no, I just said, have I misunderstood your...
No, it's certainly, as I think I said yesterday, that essentially the solicitor, and it's a standard law society provision, has said that it is not a CBA for the purpose of ensuring the client's rights to assessment are not eroded. Yeah. So essentially, a contentious business agreement works to the advantage of solicitors. Solicitors can elect, I don't think there's a case law on it, but the understanding of the profession is solicitors can elect not to take the benefit of that advantage to say this is not a CBA, so the client has all the default protections that you have with an ordinary retainer.
And I think the retainer actually says in terms that it's not.
Precisely, yeah, that's quite right.
Right.
Forgive me, my lord, I hadn't realised the
your point, Mr Kirby, is that these sections illustrate you can have a contentious business agreement even if proceedings are not brought in court.
Correct. Yes, my lord, that's right.
Yeah. I think we all think there's some doubt as to whether that's really the effect of section 61(6).
And
but that is your submission.
That is my submission. Yeah. And the following on from that, although as my lord the Chancellor has pointed out, it is a completely separate point, that the work covered by the CFA in this matter, the CFA was clearly designed for contentious business.
It might not have settled at stage 2. Proceedings might have been issued, and it was intended to cover proceedings if issued, was it not?
Well,
no. No.
Well, I think. Well,
okay. But it wasn't, was it? I mean, the point was that the solicitors always replaced it when proceedings were issued with another agreement. No.
Well, my lord, I don't think that can be correct. I mean, even if it's a point against me, but I think I'd agree with my lord Nugee, Lord Justice Nugee. If one goes to the CFA, and
I thought that's what Mr Brett told us.
No. Well, it depends whether you saw his second corrective statement or not.
Right, okay.
Originally, he'd said in his witness statement that that it was a non-contentious business.
No, I thought Mr Brett, we were told that the general practice, not in this case, was to replace the agreement with another agreement when proceedings were issued. That's what I thought was the case. But maybe that's...
I don't believe that to be the case. If I have...
So this agreement carries through to contentious business?
Well, indeed it does. My lord, I do wish in the light of this point being raised, I do wish to take my lord to it, even though I know we've looked
Yes,
at it.
because I thought the rules about CFAs. I thought it was. I mean, maybe I'm thinking back inaccurately, but I thought the rules about CFAs made it difficult for this type of agreement to be entered into in relation to proceedings that have started.
Well, my lord, we do suggest or submit that the consequences of it being found that this is all non-contentious business could be difficult for a number of solicitors if they are all relying on a CFA that has been drafted in terms that refer to proceedings, if it's now said that in fact it simply relates to non-contentious business. My lord, the Conditional Fee Agreement is on page 333 of the core bundle. And if I can take you to page 334, what is covered by the agreement? Your claim for damages, any application for pre-action or non-party disclosure, any appeal by your opponent, any appeal you make against your interim order or an assessment of costs, any proceedings you take to enforce a judgment, order or agreement. My lord, if you go to page 335, you'll see in the second paragraph, if you win overall but on the way lose an interim hearing, you may be required to pay your opponent's charges. My lord, under the heading on that page, what do I pay if I lose? If you lose, you'll normally have the benefit of a quox, so the court will not usually enforce an order for costs against you unless the proceedings have been struck out, the claim is fundamentally dishonest, or the claim includes a claim for the financial benefit of someone else. My lord, if you go on to page 337.
Well, the provision that I had in mind is on 336, just before the signature. Parties acknowledge and agree this agreement is not a contentious business agreement.
Yeah, but my lord, declaring it not to be a contentious business agreement doesn't mean that the work that is covered by the agreement is not contentious business. Simply means it's not a contentious business agreement within the meaning
clearly,
of the
if
section.
proceedings had been commenced in the county court, then we wouldn't be here, because section 74(3) would apply on your case.
But, my lord, can I just go to the other references?
Yeah.
337, middle of that page above the whole punch. Well, if you're working electronically, you won't have that. But there's a reference to the success fee and the cap on the amount of the success fee, which are awarded to you in proceedings covered by this agreement.
Yeah.
If you go over to the Law Society conditions, which start on page 340. The third bullet point in terms of responsibilities, you must not deliberately mislead or provide instructions which result in the court making a finding of fundamental dishonesty. Over to 341, there's a heading, if your opponent fails to pay monies due to you, and there's the solicitors have the right to take recovery action. Payment for advocacy. Over to page 342. What happens after this agreement ends? We may apply to have our name removed from the record and any court proceedings. At the bottom of 342, there's the explanation of the word advocacy, which is appearing for you at court hearings.
If it helps, Mr. Kirby, I accept that if there had been contentious business, this agreement would have covered it. It wasn't the sort of agreement, I think my Lord the Master of the Rolls referred to, which does exist, which only covers pre-proceedings. This is an agreement which clothes everything, pre and post. Yeah. So if Mr. Kirby is engaging this exposition to convince you it would have covered proceedings if there had been some, then I agree with that.
I'm grateful.
And in that case, section 74(3) would have applied as well.
Yes,
because there have been proceedings in the county court.
And then it's
It would have been contentious business.
and then unless Mr Justice Wynne Parry is wrong, and I'm looking forward to hearing about that, then everything becomes contentious business.
Yeah.
Yeah, but
That's the whole point.
so our whole
isn't
point
it?
is that trigger was
Everything you've done up to date. If you commence proceedings in the county court, everything that's happened up to date becomes contentious business.
Precisely. I think as my Lord the Master of Oath says, it's a watershed, but it's a watershed that when you pass through it, it sort of transforms the watercourse behind you as well.
What's the, while you're up on your feet, what am I thinking of about the statutory restrictions on CFAs in this kind of business?
I believe what your Lordship is referring to is, I think all sides, first of all, I think all parties agree that some solicitors, and I don't think it's ever been suggested it's anything like all of them, but it exists in the market as a model, that some solicitors will have a non-contentious business agreement up to the point of issue. And the reason that is significant, and it's something the Law Society raises, is on the current understanding of the law of that being non-contentious business, it doesn't have to comply with the damages-based agreement regulations.
Exactly.
And those are very draconian regulations if you get it wrong, because there's a statutory unenforceability sanction which there's no judicial discretion
This
to
does
alleviate.
comply with the DBA.
This isn't a DBA at all. So it doesn't. A DBA is the jargon for a contingency fee agreement where you get a percentage. You just get a flat percentage of the damages. So I think that's what your Lordship has in mind. There's some evidence, and I don't.
Yes,
I don't. Yeah, it's sort of queer TMET evidence that's saying, look, if you unwind this, disaster could strike a lot of solicitors with this business.
I think that was my confusion. I'm very grateful. Thank you, Mr. Kirby. That was my confusion. I was reading the DBA material.
Yes, unless my Lord was also thinking about the earlier conditional fee agreements regulations, which have to stipulate the proceedings to which the CFA related. They are.
Yeah, I wasn't thinking of that.
But the repealed or revoked rather. Regulations are at page 330 of the statutory material, and a conditional fee agreement must specify the particular proceedings or parts of them to which it relates. So when, and I guess this is moving on to proceedings, but while I'm on that subsection, I'll deal with this. So it's clearly an example of where proceedings would not be existing proceedings, because otherwise you couldn't have a CFA before you actually issued the claim. But you would still have to specify within the CFA the proceedings, i.e. the proposed claim in the Watford County, I think it might be one of the ones they've shut, but in the Central London County Court for the recovery of X, Y, or Z. But it was necessary in order for it to be a valid CFA to specify the particular proceedings to which it related. So in that context, clearly proceedings didn't mean proceedings that had already commenced.
That was in the era when you could recover the success fee and things like that.
That was in that era, and indeed in the or shortly after the era of the Cost War One. Yes, so. There were more stipulations with regard to CFAs.
But I mean, your point, just to come back to the contentious business in hand, your point is this contemplates proceedings, and nobody disputes that. The CFA contemplates proceedings being issued, if necessary.
Well, that probably means I can skip on a fair bit.
Can I just be sure I understand what is common ground? As I understand it, it's now common ground that this agreement would continue in place if proceedings had been issued, that those, once proceedings were issued, anything more done would be contentious business, and because of the retrospective effect, anything done in preparation up until that point would then be contentious business. That's all common ground. The only thing that's not common ground is the position we are in fact in, where it settles before proceedings are issued, whether it is then contentious or non-contentious. Have I understood that correctly?
Yes, that is correct. I mean, for the purposes of this appeal, the issue is whether work done in relation to the portal
Yep.
is contentious. So I don't have to go further than that at the moment, and this court doesn't have to embark upon a consideration of employment tribunals where there are different considerations, etc. The point in this case is whether work done
Through the portal.
Yep. is contentious, and whether work done in the portal is included within, or should be, whether the wording proceedings in the county court should be construed to include a claim that's initiated in the portal.
Yeah.
Yes.
And if you're against me on either of those, or both of them, but if you're against me on either of those, then 74.3 does not have an impact.
Yep.
So, seeking to shy away from that at all, that's obvious.
Yeah.
Yeah.
My lord, can I actually take you to, because we haven't actually looked at it, can I actually take you to the decision in Simpkin Marshall?
Yeah.
Well, that's in the authorities bundle.
Simpkins Marshall is Win Parry.
Yes. It's
Authorities bundle 1.
bundle 1, divider 6, page 81. This is dealing with the Solicitors Act 1957, and you'll see from the head note on page 81 that not only all business done in the course of proceedings was to be regarded as contentious, but also all business which was done before proceedings were begun, provided that the business was done with a view to the proceedings being begun, and they were in fact begun, all other business was non-contentious. So that is, and I accept, that is the position that is assumed in Cook on costs, in Friston on costs, and the position that my learned friends put forward as being settled law.
And there's no relevant difference between Section 86 of the 57 Act and Section 87 of the 74 Act.
Yeah, there is. I'm going to take you to that. Sorry, there's no difference between those, no, but there is that when I take you to in re solicitor, I accept, as my Lord the Chancellor said, there is a difference between that wording. My Lord, page 85. Well, you'll see the sidebars parse, and the first two sidebars just introduce the issue. But at the bottom, in the ordinary course, business consisted of advising whether or not proceedings should be started as non-contentious business. Only becomes contentious business if proceedings are in fact started. Hence the necessity in defining contentious business to include not only the preposition in, but also the words for the purposes of. It will thus be seen that in the ordinary case, the test of whether business of advising on the question of bringing proceedings is to be regarded as contentious business depends on the course taken subsequently to the advice being given. It must follow from the argument of the applicant that supposing the business done is advising whether or not a writ of summons should be issued, the nature of that business is not to be tested by posing the question were the proceedings in fact begun as a result of the advice. The question is answered as soon indeed as the business of advising undertaken, because it is done in existing proceedings. Over the page to 87, there's reference to the definition of contentious business in section 81 of the 1932 Act. This is a narrow definition that would appear to recognise that conveyancing business done or for the purposes of an action was not to be regarded as contentious business. Just further down that paragraph, I've read the definition of contentious business contained in section 86 of that Act. This definition is very much wider in scope than the definition in the Act of 1932. Towards the foot of the page, near the sidebar, there is now a clear, and I should have thought...
Though, Mr Kirby,
sorry, forgive me?
the reason for that is that the judge is making the point that Section 81 talks about any business done by a solicitor in any court. So he's making the point, as I read it, that under the old Act, only business that was done in court by a solicitor was contentious business, whereas this definition is wider in the sense that it encompasses where proceedings are begun. It encompasses work that's been done before the proceedings started. Whereas under the 1932 Act, that wouldn't have been the case. That's I think, is what he's saying.
Well, that may be what he's saying, but he hadn't had drawn to his attention the decision in Re Solicitor, where the Court of Appeal decided that done included work in relation to content. It was the nature of the work that was being done, not simply the time at which the writ was issued. My Lord, if we go to page 90, again, the conclusion that is relied on by my learned friends, if I'm right in my conclusion that in the case where proceedings have to be begun by writ, the business of advising is referable to the proceedings if begun for the purpose of deciding in what proceedings that business is to be regarded as contentious business, I will find no good ground for not applying the same reasoning to the case of advice given leading to the issue of a summons entitled in the proceedings begun by the petition. In my view, the business of giving such advice only becomes contentious business in such proceedings by virtue of the issue of such summons. One can see from page 91, the last paragraph, that the judge explained how difficult he had found it to deal with the matter. Can I take you to in Re Solicitor, which is in bundle 3, the authorities, at divider 52.
So which page?
I'm sorry, my lord. Page 1314. You'll see in the first head note that to distinguish between contentious and non-contentious business, regard must be had to the nature of the business done and not to the time when it's performed. If work done before writ is issued is of such a nature that if the case went for trial, the cost in respect of it would properly be allowed on the party-party taxation, then it is contentious business, even if a writ is not in fact issued. But if the work would not be so allowed, then it is non-contentious. My Lord, the judgment of Lord Justice Denning, as he then was, is on page 1316. And, my Lord, the sidebar, you'll see, goes through the whole of that page and into the next page. My Lord, can I invite the court just to quickly skim read that, or I can pick out the relevant passages, but it might be quicker just to
Why
skim
don't
read.
you just pick out the relevant passages?
Well, in which case, you'll see it starts by saying there's a great difference for solicitors between contentious business and non-contentious business. And that's the start of the next paragraph. Although the difference is so important to solicitors, there is no clear guidance to be found anywhere to enable the profession to distinguish between contentious business and non-contentious business. And and in section 81 it says what is obvious, that contentious business includes business in court. We're left to find out for ourselves. We should have liked to accede to Sir Hartley Shawcross's request if we could. It seems to me that if a clear line is to be drawn, there is only one possible place for it, namely the issue of the writ or other originating process in the courts of law. All business before that date could be said to be non-contentious and all business afterwards to be contentious. It would be very convenient if we could draw that line, but I do not think we're at liberty to do so for the simple reason it's not the line drawn by Parliament. The statutory distinction depends on the nature of the business, contentious or non-contentious, not on the time at which it is done. Over the page, the first paragraph at the top, does the work take on a different character simply because the case was settled? Surely not. If it is contentious business when the case goes for trial, is also contentious business when the case is settled before the writ is issued. The issue of the writ does not alter the nature of the business, nor should it alter the method or amount of the solicitor's charges. You should get the same reward for the same work, no matter whether the case goes for trial or is settled the moment before the writ issued or the moment after it. And the consequences are referred to by Lord Justice Parker on page 1321, again where the sidebar is. Any contrary view would lead to the absurd result that the solicitor would be entitled to different remuneration for identically the same work, depending on whether the claim was settled the day before or the day after proceedings were launched. Can I use that reference to absurdity to illustrate what therefore could happen with regard to portal costs?
Just before you do, do we actually have anywhere in the bundle or anywhere in this authority the precise terms of Section 81 of the Solicitors Act 1932?
Well, it's, you mean the definition?
Well, just, yeah.
It doesn't have a definition.
No.
What it says, you can see this at page 1320 in Lord Justice Parker's judgment, is that contentious business includes any business done by a solicitor in any court. So it's one of those things which says it includes things, but it doesn't. It's not an exhaustive definition. That's the whole question which they have to decide.
And there was no equivalent of Section 474, Subsection 3 in the 1932 Act. It wasn't the 1957 Act.
Yeah, the 1957 Act came between this decision and the decision of Mr Justice
the
Wynne
57
Parry.
Act, Section 73, that Mr Justice Wynne Parry was considering.
Yeah. And what's unhelpful is to look at authorities in non-chronological order, if I may respectfully say so. Well, we've got there now.
You can say that because, in fact, the moment I took you out of order, I thought I should have gone the other way. So I apologise for that.
But what you could also tell is from Mr Justice Wynne Parry's judgment is that there was an Amendment Act, the Solicitors Amendment Act 1956, and that introduced the definition of contentious business, which then found its way into the 57 Act. Seems to me distinctly possible that was as a result of Lord Justice Denning saying it would be very convenient to draw a clear line of the issue of the writ.
Sorry to intervene, but if it helps, that's actually what the leading textbook says is the situation that the 1957 Act was amended because of Lord Justice Denning's decision.
Yeah, I think you told us that earlier on, actually, Mr Williams.
I think it may be in my learning for Mr Holland's skeleton, in fact.
Okay.
But
No, I've read it somewhere. No.
We do have the absurd consequences very well illustrated in a portal type claim. So if you have a portal claim, you have two people in a car, both injured. One settles at stage 2. One settles, or court rules, at stage 3. In order to get to stage 3, proceedings will have been issued, as in a Part 8, I think it is, claim will have been issued for stage 3. The costs in relation to stages 1 and 2, if not covered by section 74(3), are at large. The same costs in relation to the matter that are resolved at stage 3 then become covered by section 74(3). And that is, we would submit, an absurdity which the court should be reluctant to perpetuate. And bearing in mind, what is the purpose of section 74(3)? The purpose of section 74(3) was a form of consumer protection provision. It may have been an early attempt to seek to make costs proportionate, but it was to protect clients from the amount of costs that they had to pay their solicitor, unless the solicitor had got their written agreement to a larger sum.
Well, it was actually about scale costs, wasn't it?
That's another problem, isn't it? Because section 74(3) talks about the amount which could have been allowed in respect of that item as between party and party in those proceedings, which is clearly referring to what the old county court scales. So a judge applying section 74(3), assuming it applied, would say, in proceedings, there have been proceedings in the county court, on a solicitor known client basis, I will only allow, in respect of drafting the statement of claim, the scale item as between party and party, set out in the county court rules.
So it said in the county court tables, it used to say drafting statement of claim
£25.
£30, or not even £10, and you couldn't get more than that.
Well, but that's why, in fact, 74(3) didn't really bite, because you could get more than that, because there was always a general discretion to go outside the
Which is
scope.
why it's always been a bit of a dead letter, but that's not the point.
Can I ask you a slightly different question, which is that 74(3) obviously envisages that you could have a taxation as between party and party. In those days, when I don't know when what's now 74(3) was first introduced, but when we had scale costs in the county court, if you'd settled a case, you couldn't take proceedings for costs. You can't have an assessment of taxation of costs in proceedings which are never issued, can you? I mean, it just doesn't make any sense.
What, between the parties?
You couldn't have a party and party taxation under the county court, in the county court, if you've already settled your proceedings.
No, not. You could have an assessment between the parties if the case had settled, if there was a written agreement to that effect.
Really? I mean, I know now.
Well, because
you can have costs only proceedings, but I'd be very surprised if we could have done then.
Well, it would be cost payable pursuant to a contract.
You can start proceedings for costs payable pursuant to a contract and have an assessment.
Yes, it's how mortgagee costs are dealt with.
Maybe. Anyway,
so
I'm not sure those are party and party costs. I think they're
well,
contractual costs. But ignore the point, Mr. Kirby. We've got other things to worry about.
My Lord, the point that I'm seeking to make is that 74(3) was introduced. It may not have had the bite that perhaps Parliament intended it to, because finding cases where it actually has had any effect is very difficult.
You say it's a consumer protection provision. It makes no sense for it to only apply to a situation when proceedings have been issued. It's absurd. You give the two people in the car example, which is a perfectly sensible example. And so you say we should strain every sinew to make it apply beyond that and to make it consistent. But how can we strain every sinew when the words are, is proceedings issued in the county court?
It's proceedings begun.
Begun.
By construing begun to also mean, but for settlement would have been begun, because the portal...
Begun equals wouldn't have been begun.
But
You know,
settlement.
unfortunately, you've got two chancery lawyers.
Well, you've got
in this
done
court.
by him as well, done by him in the county court. Well, never mind the chancery lawyers, the commercial lawyers don't. They're not either.
And I'm
You're
only
asking
a
us to
chance-
read done by him as meaning done or which would have been done.
Just for the avoidance of doubt, I'm only a chancery lawyer when it suits me. I'm also a commercial.
Would have chosen any other path. The portal, as we moved on to that, there's only two ways out of the portal. One is you've settled, but if you haven't settled, then you're out of the portal and you're into the county court.
Yeah.
So it's a funnel. I think it was a phrase that was perhaps used by my lord the.
You're doing well, Mr. Kelly.
Well remembered, Mr. Kirby.
It's a funnel where the only place you're going to come out is the county court. I mean, it may be said, well, you could abandon the claim.
Settlement or county court?
Settlement or county court.
Or abandonment. Or abandonment.
Or abandonment, yes.
You might well have a case where the insurers push back very heavily and say no liability. A solicitor advises the client, actually, you're not going to win.
I accept abandonment is one of the possibilities.
It's very rare.
But if you are going to be, if you, the claimant, are going to be awarded any costs under the portal, it's because you haven't abandoned your claim. And therefore you are getting costs from the defendant insurer, either at stages 1, 2 or 3.
And they're cumulative. You get £200 at stage 1, another 300 at stage 2, and then a bit more at stage 3.
That's right. That's right. And what's more, I mean, it is well, I know, I shan't pass any comment about it. But the portal does, under the portal, in fact, you get paid as you go along. So once you've done stage 1, you get your £200, even though you haven't yet settled the matter. And stage 2, you get your £300. So again, one has the somewhat bizarre situation that if a client, for instance, wanted to challenge, I can't imagine they would, but if they wanted to challenge the costs in relation to work done at stage 1, the solicitor had already been paid that £200. Does that amount to a payment on account? Does the solicitor send out an interim bill? But that is probably stretching the examples too far. But yes, you get, they're cumulative and you get it as you go along. And indeed, the amounts that you get are payable to what's called the legal representative, so the solicitors. And the legal representative is the term that is defined in CPR 2.1, I think.
Not in the protocol?
No. Well, it refers to the definition in the CPR. Sorry, the protocol refers to the definition of CPR. So it's defined by reference. And legal representative, and I'm sorry, I can't recall if it's in the bundle, but in the white book is on page 64. Legal representative means a barrister, solicitor, solicitor's employee, etc., who has been instructed to act for a party in relation to proceedings. So the reference in the protocol to legal representative and the definition of a legal representative again takes one over to the definition in the CPR, and the CPR's definition refers to proceedings, even though obviously at that stage there would not be proceedings at stage 1 and stage 2 if proceedings has to be limited to the actual issue of a
Well,
county
that
court
begs
claim.
the question of what a proceedings are.
Yes.
No.
But your problem is not the word proceedings, because we know proceedings is a protean word and can mean all sorts of things. Your problem is the word begun, because you need us. I'm just looking at what are the words we actually have to construe, and there's two. There's Section 87, in or for the purposes of proceedings begun before a court, and you need us to read that as meaning for the purposes of proceedings which are either begun or would have been begun or are about to be begun, or to put it more simply,
Maybe begun.
to be begun. Proceedings to be begun. That's what you need us to do there, and you need to do it again in Section 74, which is all dealing with business done in county courts, done by him in the county court, and you need to get us to construe that as to meaning done or to be done in the county court.
Or, which would have been done, but
Or would have been done.
for the portal,
Which would
because
have
the
been done but for
portal because the portal is introduced, and as I say, the only way out apart from abandonment and settlement is the county court. So it's a
That's your funnel point.
device to deal with cases, and I accept that the wording of the protocol refers to avoiding proceedings, but it is a device that is used in order to deal with claims which would otherwise be in the county court, where if they are not resolved through this particular technological process, which is only possible by reason of improvements in technology, would be in the county court. So if 74.3 was, if the intention of Parliament behind 74.3 was to ensure that where you have a system where court rules provides for what at that time was scale costs or now fixed costs, that the solicitor should have its client's written agreement to charge the client more than that, if that was the intention, then the intention, we would say, must clearly have been with regard to a process which is the equivalent now of issuing a claim, wasn't even called a claim form those days, was issuing a summons in the county court. Because at that stage, the only way you could bring a claim was by issuing a summons for a few hundred pounds.
Why? Because Parliament was talking about the bringing of proceedings in the county court. If Parliament had intended at all costs by the solicitor which were preparatory to proceedings in the county court, even though proceedings weren't commenced, it would have said so in 1956, but certainly in 1974. I mean, you're asked. You've got two problems. The one is the problem that my lords identified, and the other is the problem that in 1974, of course, as you rightly say, none of this was even invented.
Well,
online procedures and portals and so forth.
Well, my lord,
Anyway, there we are.
obviously we say the fact that none of this was either invented nor indeed envisaged, apart from perhaps some science fiction writers, because none of this was invented in 1974, that's a reason for applying an updating construction, not a reason for not applying an updating construction, because an updating construction will often be applied because of technological changes that have occurred over the period since the statute was originally passed.
What's the name of the Supreme Court decision, judgment of Lord Kitchen, about updating constructions?
Is that the embryo case?
I don't know. I don't remember.
That's today they were just talking it.
Is it in the bundle?
Well, there's a Lord Bingham case, isn't there?
Yeah,
Well, the latest
The
one.
case about dogs.
Yes, but
but with the dog as a cat.
but the latest one is Lord Kitchen, who just takes it a little tiny bit further.
Yeah.
Do you know the name of that case?
Have we got it in the bundle?
I don't know. Maybe not. We can find it.
Well, let me just get through.
It's the sort of latest thing the Supreme Court have delivered. And we gave a judgment recently in a case about VAT, in which we upheld that. The dicta in that. I mean, upheld it, obviously, applied it.
Well, I don't think that is in the bundle.
Probably quite important.
But, well, assuming I don't finish in the next 57 minutes, perhaps I could bring it to court tomorrow.
That would be helpful.
Well, we do deal, obviously, with our submissions with regard to updating construction in our skeleton argument. And of course, just as a general point, I'm sure neither my learned friends nor I are purporting to cover absolutely every single point that's in our written skeleton arguments, which are obviously quite lengthy. Well, we deal with updating construction at in the supplemental skeleton argument in supplemental bundle 1, page 149, paragraphs 83 through to 91. But I don't think we have referred to the case that my lord has referred to.
No.
So we will find that overnight. Well, what we do say with regard to updating construction, if I can make these points as to matters that the court should take into account when deciding whether to apply an updating construction, we do say that the following 7 points, although I accept there's overlap between them, should be taken into account. First of all, this is an MOJ portal, which, whilst described as voluntary, is in reality compulsory because of the cost consequences of not bringing the claim in the portal. Secondly, and I think this is now agreed, proceedings is not a term of art. And so we say one should look at the statutory context and what was the underlying purpose of the provision of section 74.3. We say that one of the aims, thirdly, one of the aims of the protocol is for a legal representative to receive fixed costs at each appropriate stage. And the definition of a legal representative being the one at CPR 2.31. For my lord's reference, the protocol, the relevant section in the protocol is at divider 31 in the core bundle at page 293. Fourthly, CPR 45 deals.
Sorry, I thought these points were in your skeleton, but they're not, are they?
No, I'm distilling them from the skeleton.
Could you just do me the favour of just going back and just enumerate them from number 1 quickly?
First one, this is an MOJ portal.
Yeah.
And in reality, it's compulsory.
Yeah.
Secondly, proceedings is not a term of art. Look at the statutory context, what was the underlying purpose. Thirdly, the definition of legal representative, which I referred to earlier.
Yeah.
Fourthly, this is a point I hadn't yet got onto. Fourthly, CPR 45 deals with fixed costs, and fixed costs includes the fixed costs of the legal representative. and one can see that CPR 45 provides for the legal representative to receive an additional 12.5%, whilst the matter is at stage 1 and 2.
Basically, CPR 45 includes portal costs.
Includes portal costs. Definition of legal representative is by reference to proceedings.
Yeah.
The additional 12.5% is with reference to where the lawyers are, and again refers to proceedings. Fifthly, the section was, we say section 47.3 was designed, sorry, 74.3, was designed to cap a solicitor's costs to the sum recoverable from the other side where there are fixed costs provided by court rules, and it's still intended to bite. And we refer to Lynch and Paul Davidson Taylor. My lord, perhaps I can...
Can you just give me that fifth point again, Mr.
The fifth point
Yes.
is designed to cap a solicitor's costs to the sum recoverable from the other side where there are fixed costs provided by court rules, and the intention is still that that section should bite, and that's a reference to a judgment in the case of Lynch and Paul Davidson Taylor. That is in Authority Bundle 1. That is at divider 21.
Page 415.
Page 414.
Yeah. 5 in the electronic, yeah.
I'm sorry, yes, I should remember the plus one. That was a decision of Ms Justice Hughes. You will see at page 418, 419 electronic that there's a reference there, or rather there had been a reference in the Claims Direct test case to section 74.3 of the 1974 Act.
Yeah.
But the passage I really want to take my lords to is on page 420, 421, where Ms Justice Hughes at paragraph 19 says, I'm satisfied that section 74.3 of the 1974 Act exists to apply a cap where there are limits under the rules to the level of costs recoverable as between the parties. And just skipping down, if I may, a few lines to just below C. Under the new civil procedure rules, the express reference to section 74.3, which appears in rule 48.8.1a, shows that the section does not simply survive, but is intended still to bite. And bite it does wherever there are fixed, i.e. maximum costs. There are fixed trial costs in all fast-track cases which reach trial, provided for by Part 46. There are fixed costs in small claims track cases, provided for by Part 27. In each case, there are very limited exceptions to the fixed costs provided for, one of which is where there's been unreasonable behaviour by a litigant, but those exceptions do not mean that it is not possible to say in a fast-track or small claims track case what is the amount that could have been allowed as between the parties. And in such cases, the solicitor is limited to that sum as against his own client, unless there exists the kind of written agreement provided for by Rule 48.8.1a. 48.8.1a was obviously the predecessor.
Yeah.
And there's a bit of advice to solicitors in the final paragraph at 21 that solicitors need to be ever alert to Rule 48.8.2c and to the necessity to advise their clients of costs which may not be recoverable from the other party even if the litigation is entirely successful. The advice of the Law Society that solicitors' terms of business should routinely be put in writing is plainly sound. Consistently with the presumptions inherent in the indemnity basis of taxation, solicitors can still expect careful examination of the contention that the client has expressly or impliedly authorised costs. They need to be alive to the continuing need to give clear explanation to their client of how the costs are running and how they affect him, and if it's an appropriate case, to the need for an express written agreement under Rule 48.8.1a. So, whilst in that case, 74.3 did not bite, it's clearly indicated that is the intention, that it should bite. And of course, it has been maintained on the statute book and of course referred to in the CPR by amendment. The amendment being referred to there, and my learned friends say that the reason why it was introduced at the last minute into the rules was because of, in particular, the introduction of a fixed fee with regard to trial costs. So, we say that proceedings begun in the county court should extend to proceedings in the portal by giving it an updating construction and by considering the purpose of Section 74.3 and that those 7 particular points that I've just made should be taken into account when or rather, I only got to point 5.
Yes, I thought you.
I'm sorry.
You've got 2 to go.
Yeah, I've got 2 to go, but I think they've to some extent been covered. But point 6 is court rules apply, and the protocol claim relates to county court proceedings. That it's the county court that has to determine any disagreement between the parties under the protocol. So that's a bit of a funnel point again. And point 7 is also the funnel point. Once in the portal, absent settlement or abandonment, the only way out is the county court. I've given the example of the 2 people in the car who are both injured, one who settles at stage 2 and one who settles at stage 3. That even poses problems for solicitors, because if you had a retainer that had not excluded, it was not a written agreement for the purposes of Section 74.3, you'd be faced with a situation where if the matter settled at stage 2, costs would be at large, subject to them being reasonable. If it's settled at stage 3, you might be restricted, you would be restricted in the absence of written agreement to the fixed costs. So making that, applying the strict wording of the section and not giving it, what I have to accept is to an extent a strained construction, would actually leave the solicitor's profession in an invidious position at times. Well, can I come on to the next point, which is whether the fixed costs for stages 1 and 2 limit the amount which may be allowed in respect of any item and impose an absolute limit on the fixed costs that could be recovered inter partes. Well, the fixed costs allow a sum in relation to legal representatives' fees. They allow a sum with regard to disbursements, and obviously the bill is also going to include VAT. There could be a number of disbursements, not necessarily one. Mm-hmm. And if the amount allowed by way of the legal representatives' fees is, say, £500, that is an item, albeit it is a global item. It is still an item on a bill. It is the sum of £500 in relation to the services provided. There is then a sum of, let's say, £150 for disbursements. There is a sum in relation to the success fee. That's not going to be covered so long as the client has given informed approval to that. and there's going to be a sum in relation to that. So there are items, albeit not, one letter, 6 minutes, and should it be in 12 minutes? But nevertheless, it doesn't refer to detailed item, and we would say that therefore it is covered by the Act. And indeed, it would be odd if it wasn't. What would be the point of having this protection if, when you then do actually introduce not a system of scales but a system of fixed costs, if they were not to have that bite? So,
but isn't that the effect of Mr Justice Hughes's judgment? I mean, it isn't the effect of his judgment that he's saying that even though we no longer have scale costs, fixed costs, as it were, amount to an item.
Yes, sorry. Yes,
Yeah.
I mean we do say that. We say that it was intended to bite, and it's still intended to bite. And so, so far as that is concerned,
But we don't have to decide that.
No.
well, it's my understanding is that it's a point taken by my learned friend Mr Williams.
What?
Depending upon what my lord meant by.
What do you mean? What point taken by Mr. Williams?
Well, my understanding is Mr Williams takes the point that
It's all about the scale costs. He doesn't take the point, as I understand it, that it wouldn't apply if proceedings had been issued.
I thought he did.
Sorry, I forgive me if I'm responsible. But I think I obviously do have the argument that which I touched on yesterday, and I developed much more the first time round. That where 74.3, what 74.3 is envisaging is an inter partes assessment of items, and therefore, and that's the scales point. So that what the section 74.3 doesn't operate in conjunction with a modern fixed cost system, and to that extent, I would respectfully part company from Mr Justice Hughes.
So you say he's wrong?
I say he's wrong about that. I mean, it was a
case
case about something completely
You didn't
different.
mention the case in your
It was.
skeleton.
I can't remember. I think we do cite Lynch in our skeleton, but we
It's a backup point, isn't it?
it's a backup point. Yes, if I'm right about contentious business, it's a backup point. But nevertheless, I do say it's a point I do maintain, and I think I touched on it yesterday. I obviously knew that Lynch was coming anyway. I cited it myself. My learned friend cites it, but I think it was agreed that I would deal with a bit more in my reply than was initially anticipated. But if I should have shown the court, I apologise.
No, it's fine.
It's okay.
Well, we say that when you look at 74.3, it says the amount which may be allowed on the assessment of any costs or bill of costs in respect of any item relating to proceedings in the county court shall not, except insofar as rules of court may otherwise provide, exceed the amount which could have been allowed in respect to that item as between party and party in those proceedings, having regard to the nature of the proceedings. So when you're assessing a solicitor an own client bill, the amount that you can allow in respect of any items relating to the county court proceedings, so if it was conduct of the matter and a number of letters between, well, in this case, if you're against me on contentious, and proceedings from the day that you send off the CNF, claims notification form, through to settlement, what does that lot add up to? And how much could have been allowed in relation to that in the county court? Well, we know under the fixed rules, fixed costs, and we know how much could be allowed in relation to that because they're fixed. So the fact that the solicitor own client bill may say, calling you on the 4th of January 2019, 1 unit, £10, does not mean that there has to be that same unit in the fixed costs, because the fixed costs are global. They are fixed costs in relation to the legal representatives fees, and then there are fixed costs in relation to disbursements. So each of those elements are determined by the fixed cost regime. So we don't actually, in a sense, understand the point that is made by my learned friend, Mr Williams, on behalf of the appellant. My lord, there is one of the issues in the case is whether CPR 46, and this is the next point, 46.91 enlarges the application of section 74.3 so that it extends further than contentious business proceedings in the county court. My lord, the court rules, this is a point that was discussed to some extent on in February. I think it's a point that at that stage, my lord, the Chancellor raised with the parties. The court rules are obviously made pursuant to section 51 of the Senior Courts Act, which provides that the court rules may make provision for regulating matters relating to the costs of those proceedings, including in particular prescribing scales of costs to be paid to legal or other representatives. And the power, we say, therefore, under section 51 is a very wide one and includes rules as to how much should be paid to legal representatives, or could include, and does include, matters to take into account when determining how much should be paid to legal representatives. 4691 says in terms that it applies to every assessment of a solicitor's bill to a client. There are then a number of limited exceptions. There is no exception in relation to non-contentious costs. Now, my lord, the predecessor of 46.9, and if I can take you to Authorities Bundle 1, I think I may have the wrong reference there, forgive me. I think it may be the statutory.
Statutory instruments.
Statutory. Divider 12.
This is the county court. The Supreme
It's got various bits behind this divider, but if one goes to page 132, you'll see from 131 that this is the Supreme Court practice in 1985. That Order 62, Rule 29, provided on the taxation of a solicitor's bill to his own client, except a bill to be paid out of the Legal Aid Fund under Legal Aid Act 1974, or a bill with respect to non-contentious business, all costs shall be allowed except insofar as they are of an unreasonable amount or have been unreasonably incurred. That therefore,
well, 2 and 3 are effectively an older version, aren't they, of rule, what's now 46.9.3?
yes. I mean,
what's now 46.9.2
isn't
came in 2000.
Yes.
With the CPR, so it was never in the
No,
RSC.
I mean the point, and it's a very minor one. That the point is that the drafters of the rules at various stages, in relation to certain solicitor-owned client assessments, have excluded provisions with regard to non-contentious bills. So that's what happened in Order 62, Rule 29. There's no exclusion, exception rather, under 46.9.1 in relation to non-contentious
But
business.
wouldn't you have to, for this argument to work, wouldn't you have to persuade us that somehow 46.9, specifically 46.9.2, had extended the scope of section 74.3 of the Solicitors Act? and yet on the contrary, it doesn't do anything of the sort. It simply says it applies. I mean, if you're wrong about the construction of 74.3,
Yes.
then 46.92 doesn't apply. It can't apply because it's only where section 74.3 applies, which on this hypothesis it doesn't.
Well, I think I have to accept that point. I can't see
Yeah.
why that is not entirely logical.
So I'm not sure where this point takes you.
Well, what,
You may very well be right that it doesn't, non-contentious isn't dealt with, etc., etc.
well, non-contentious is not accepted.
I mean, what you need.
But I've still got to get with the
You
point
need
of my lord. I think
46.92.
I've still got to get over 74.3.
Home on anything.
Yeah, I accept. I still have to get home on 74.3.
Well, if you get home on 74.3, this point doesn't matter.
Again, I think that I think that must be right. My lord, can I then come on to deal with the need for the written agreement under 4692?
Why does that matter?
Why does it matter?
Need for a written agreement.
Well, because
4692.
if
Because you say there.
I say that's not sufficient for a
Oh,
written.
you mean written agreement plus implied or express or implied
So
consent?
you assume you're right about 474.3, and you said there wasn't a sufficient written agreement here.
Yeah. So I have to deal with 4692. Obviously, I'm conscious of the remarks made by my lord, the Master of Rolls, and indeed my lord, the Chancellor yesterday. But
No, you've got to deal with it.
Yeah.
indeed, well, first of all, the rule provides that unless the solicitor and client have entered into a written agreement which expressly permits payment to the solicitor of an amount of costs greater than that which the client could have recovered from another party to the proceedings. There's nothing in the CFA or the 41 pages of documents that makes any reference to permitting the solicitors to be to avoid the consequences of 74.3. So 4692 is all to do with the effect that section 74.3 would otherwise have. And yet there is nothing in, as I say, the 41 or however many pages there are, that makes a single reference to 74.3. So we would say that expressly permits must be, well, what is it permitting? And why is it permitting? Well, it's expressly permitting avoiding the consequences of 74.3. Otherwise, it's not required, for instance, with regard to non-county court proceedings.
Where's this in your skeleton, this part of your argument?
That particular submission is the submission I've just made is not there, but it's
Because I'm
I
just.
mean, is this an argument that an argument that the CFA ought to have included an express statement that it was intended to exclude the application of section 74.3 of the Solicitors Act?
our main submission. Our main submission, as I know Junior's just pointed out, is at page 158 of Supplementary Bundle 1, paragraph 125.
158, yes.
Page 158, paragraph 125.
That's about informed consent being
The
required.
concept of the client giving informed consent to fees being incurred is important for two reasons. Firstly, there's an obvious disparity of knowledge and understanding between the solicitor and the client. Secondly, the CPR at 4693 imposes a rebuttable presumption of reasonableness as to the fees, whether they're incurred with the express or implied approval of the client. What the submission I made just a moment ago, and I was asked where is that submission in the skeleton argument. That submission in those terms is not in the skeleton argument. It is one that I've considered overnight in the light of the comments that were made by the bench yesterday with regard to, well, if it's a written agreement, it's a written agreement. But the words are expressly permit, and what is the written agreement intended to cover? And it's intended to cover the non-application, or intended to allow Section 74(3) to be avoided.
But that's effectively equivalent to saying that it ought to, when it says expressly permits, etc., etc., it also includes expressly states that Section 74(3) of the Solicitors Act doesn't apply. And those words aren't in the rule either.
No, they're not. Of course they're not. I accept that.
Would it be enough if it said, under this contract, you may have to pay the solicitor, me, more costs than you can recover from the other side?
Well, my lord, I'm going to come on to submit that our case is that a solicitor should, in relation to a portal matter where there are fixed costs,
Identify what the fixed costs
identify what those fixed costs are, because the client needs to know. I mean, I think, obviously having sat here for a day and a half, I think most people in this courtroom would accept that the explanation given with regard to the costs was not ideal.
But that's not the question. The question is whether it complies. This question is whether it complies with 46.92. And what 46.92 requires is a written agreement. You've got a written agreement. And it has to say something express. It has to expressly permit something. And what it expressly permits is payment to the solicitor of an amount of cost greater than that which the client could have recovered from another party. So my question is, if it says expressly, we can recover more costs than you can have recovered from another party in certain circumstances, is that enough?
Well, my lord, we would submit no. It should say in 47.3, therefore does not. Sorry.
And therefore Section 74.
And therefore
that's
section,
effectively my lord's
yes,
point.
And therefore
it
section,
should expressly say.
And therefore Section 74.3 does not apply.
Yes, we're trying to exclude the benefit of a statutory provision which you would otherwise have.
Yeah.
Okay.
And indeed, I think a number of solicitors' retainers do actually refer to the particular section. But this client would have, however sophisticated she might be, I would hesitate to suggest there are a number of solicitors who themselves are unaware of Section 74.3, let alone, I know it's difficult to believe, and certainly the suggestion that a client coming in off the street would have any idea of Section 74.3 is obviously farcical. My lord, again, I take on board the points that were made yesterday by the court. But we do say that the express written agreement, or the written agreement which expressly permits, does require informed agreement by the client. We say it is an odd situation if an element in a bill, such as a success fee, required informed approval if it was of an unusual nature, but that a statutory provision introduced by Parliament to restrict the costs that solicitors can claim from their clients, if such a provision did not require informed approval. we in Herbert, the documentation, as my learned friend has prayed in earlier this afternoon, the documents received a certain amount of praise from the Master of the Rolls. And the issue there was the use of 100% success fee, as it happens, which also appears in this case, 100% success fee. And that was considered to be unusual because it didn't take into account the risk element. So that element of the bill was reduced from 100% to 15%, or rather the district judge's decision to allow 15% was upheld. Here, there is, without any reference whatsoever in the retainer documentation, there is reliance on the wording of that documentation to remove from the client the statutory protection that 74.3 would provide. And bearing in mind the effect of that, we say that that is a matter that the court should take into account when construing the words written agreement which expressly permits. I'll come on to deal in due course with regard to fiduciary duty, but we say that that of itself, as a matter of construction, that the court should not apply a different test to the words written agreement which expressly permits, a different test to the words approval. I mean, approval is someone agreeing to something. And in a sense, what Ms Belsner is agreeing to here is something more drastic than a high success fee. She's agreeing to something without any indication from the lawyers as to what it is that she is being asked to agree to. At the time of the retainer, so in the CFA and the retainer documents, what is actually Ms Belsner told? She's told that the costs are estimated to be £2,500 plus VAT and disbursements. She's told that she is entitled to seek recovery of part or all of our basic charges. In another place, she's told that you can normally claim part or all of our basic charges. In another place, she's told if we cannot agree the amount of costs, the court will decide. Well, obviously that's misleading because the costs are fixed, so the court's not going to be deciding them. She's told that the charges may exceed the costs recoverable. There may be a proportion you will have to bear. So that's effectively the provision relied on. That's page 347. She's told that the usual position is that the losing party will be ordered to pay a significant part at least of the winning party's legal costs. That's page 347 of the core bundle. We say that as at the date of the CFA, the 18th of March 2016, the solicitors and Ms Belsner were in a relationship where the solicitor owed fiduciary duties to the client. We say that included within those fiduciary duties is a duty not to take unfair advantage of Ms Belsner.
Well, hang on. A duty not to take unfair advantage.
Yes.
Where does that come from on the authorities?
Well, we say that comes out of the duty of loyalty.
Well, is it in Mothew?
No. But when it's referred to in it's referred to in the code. Now, I accept the code as a different document, but bear with me.
Have we moved away from implied approval,
Sorry?
or are we still on implied approval?
We're on implied approval, but I'm
putting a
introducing
gloss
fiduciary
on.
duty in order to bolster the argument as to why there should be why there should be informed approval. Sorry, not implied approval.
Informed approval, yes.
So part of the reason why there should be informed approval is because of the fiduciary nature of the relationship between the solicitor and the client, and obviously the courts over many years have recognised the fact that solicitors are far more knowledgeable of legal matters, are in a position to exercise greater influence over a client. There's an inequality within the relationship. And that is why the courts over many years have been astute to actually consider very carefully the arrangements that solicitors reach with clients. My own friends referred earlier to the recent Candy decision. Well, part of that is again an example of how the courts have sought to control and restrain the conduct of solicitors towards their clients to ensure fairness in the way in which solicitors treat their clients, and that solicitors don't take unfair advantage of their clients.
Yeah, and that's a big difference from saying that a fiduciary relationship, which is something that has been very well understood by the courts for hundreds of years, includes a duty not to take unfair advantage. It may be that in some cases, if you take unfair advantage of your client, you would be in breach of your fiduciary duty of loyalty, or you would be benefiting yourself at the client's expense without fully informed consent, or you would be making putting yourself in a position where your duty and interest conflicted. That may all be the case, but that formulation is simply not a formulation that has any authority backing it up.
Well, I'm grateful to my Lord for the way in which my Lord puts this, and if I could...
Well, I put it, it's almost a precise quote from Lord Justice Millett in Mothew, who took that from Finn and hospital products, and those are the leading authorities on this area of the law. I prefer those, personally, speaking only for myself, to the latest authority in the Supreme Court, simply because I think that they don't. I think it's just clearer. But I mean, to be absolutely clear, speaking only for myself, to succeed on this point, you have to show that it was a breach of fiduciary duty in that the solicitor benefited himself without the client's fully informed consent by entering into this contract. In other words, you have to show what in this contract benefits the solicitor without the client's fully informed consent. Now, my problem about that is that I don't think you, if I may respectfully say so, in your skeleton, really identify what it is that is a breach of fiduciary duty. And that is the only possible breach of fiduciary duty.
Well, my Lord, let me attempt to do that now.
Yes. What is the term? What did the solicitor do in signing her up to this agreement? What was the term that was a breach?
Well, they had at that stage put themselves in conflict with the client, because at that stage, under that agreement, knowing what they knew, the solicitors would be the only people at that stage from these written documents who would benefit from that agreement.
Is that true? I mean,
I'm stating proposition. I'm now going to try and make it up.
Make it good.
Make it good. Sorry.
Yeah.
What I went through just a few moments ago, what they tell the client. One of the things they tell the client is that the cost estimates is £2,500 plus VAT plus disbursement.
well, they didn't tell her that she could only, if the case settled at a particular time, that she could only recover 1/5 of the cost estimate.
They didn't tell her that. If they enforce, they have a contract under which they can enforce the full amount of their costs. They do not tell her what amount may be recovered under the fixed costs. And so if they enforce the contract that they have got her to sign up to, they are the only people who could benefit, knowing as they did at that stage what the likely recoverable costs were and knowing what the likely award of damages would be.
You see, unfortunately, you're looking at this. I mean, a breach of fiduciary duty has to be something positive, i.e., the taking of an advantage, a pecuniary advantage, not in the criminal sense, pecuniary advantage without the client's fully informed consent. It might be worth turning up Matthew and precisely the words used. What I don't understand at the moment, I understand that the agreement was lacking in the respect you indicate. I understand that the agreement would have been far, far better if it had told her, and that to get fully informed consent to it, in the sense that is meant by Lavender J, you would need to say it, and in the sense meant by Lord Justice, by the Master of the Rolls, my predecessor, Sir Terence Act. What I don't understand, and I get all that, and it seems to me that's right, but the question is not, was there fully informed consent, unless the allegation is there was a breach of fiduciary duty at the moment she signed an agreement which is in fairly clear terms. It's just omits some information which would have been very useful if you were asking the question, did she give fully informed consent to it, which you might have been on a taxation or an assessment. But it's not what we're deciding here.
My Lord, we submit that at the point of entering into the agreement, the solicitors take pecuniary advantage of the client because at that point they put forward to her a contract which they have drafted and indeed which they charge her for drafting, and which under that contract there is no limit as to what they can decide to get her to require her to pay. And knowing what they knew at that stage, only they, if the contract is taken at face value and enforced, only they could benefit from it.
Well, is that not the case in every solicitor's contract with a client? I mean, this is precisely what I wanted to get you to formulate, because formulating it like that, and I've taken the precaution of writing it down, formulating it like that simply means that every solicitor is in breach of fiduciary duty if they negotiate terms with their client, because they can only benefit. They've obviously asked for a higher fee than the client would like to pay. Doesn't matter how low the fee is. No client wants to pay a solicitor anything if they can avoid it. Surely that is not a situation in which they are in breach of a fiduciary duty, even if they owe it. As Lord Newberger said, they have to be allowed to negotiate on their own behalf.
Under that agreement,
You might just decide they'd be in breach of fiduciary duty in my Lord's example, if they fail to say to the client, and by the way, even though we're charging you, £300 an hour, you can go down the road to Snooks and Co, and they'll only charge you £200 an hour. And there's another firm around the corner, they'll only charge you £150 an hour. So why don't?
Well, that was the.
So, I mean, but
That's
that is, if you're talking about informed consent in this context, then it goes as far as that with respect. So my Lord's point to you is a perfectly valid point. Every solicitor would be in breach of fiduciary duty on this basis.
Forgive me, but on the facts of this case, they know the extent, they know what sort of injuries she's got. They know, they've estimated what their costs are going to be.
Well, on the facts of this case, for better or worse, they were never going to charge her the £2,500.
Well, well, in our submission, you can't, on the one hand, say, this is a contract under commercial law. You've signed up for it, and on the other hand,
talking about is breach of fiduciary duty. If what you're talking about is breach of fiduciary duty, it must be relevant, mustn't it? That in fact, although you say that they were, I think you put it at its highest as taking unfair advantage, the reality was they were never going to charge the £2,500. Now, maybe that's the reason why they didn't actually say you'll only ever pay a fifth, because they never intended to charge much more than the £500. Now that one can criticise their failure to spell it all out, but to say that that's a breach of fiduciary duty seems to me at least to be going a long, long way further than.
And I'm going to bring this to an end, in just a few minutes in advance of 4:30. But there are two reasons why, putting my chancery hat on, I don't think it can be a breach of fiduciary duty at the moment. And I want you, if you will, to think about them overnight.
Yes.
And one is because fiduciary duties only exist depending on all the circumstances and the scope. They don't exist just because the person is of that type.
No.
You have to look at the scope and extent of the duty alleged. And the scope and extent of the duty alleged, even if the solicitor is obviously here a fiduciary, those fiduciary duties do not extend to his action or her action in negotiating their own fees. Right? So that's that's the first reason. The scope of their fiduciary duties cannot extend to their ability to negotiate their fees, or otherwise every solicitor. That was the point I was making when I asked you. And the second reason is connected, which is that you can't define a breach of fiduciary duty or a term in the agreement which violates any of the completely clear and defined facets of the fiduciary duty they do owe, namely taking advantage of the client without her informed consent, which is part of their fiduciary duty. But actually this agreement doesn't do that. What it does is, in pursuance of the scope in pursuance of their negotiation of their contract, it doesn't give full information, as you would have to do if the relationship was one of uber mai fide, which it is not.
Yes, excellent.
So what if there was a duty of utmost good faith? Yes, it would be broken, but it isn't, and you can't show a breach of the duty of loyalty, and it's outside the scope of the fiduciary duty they do owe. Those are the really 2.5 reasons that I would put to you as being the reason why you can't get it. It's of course a very different reason than that given by the judge.
Yes. Perhaps I could formulate that overnight.
Well, I think that would be good. I mean, I've tried to explain it.
No, I'm very grateful.
But I could have written it down. But it's that's what troubles me.
Yes, well, as I say, perhaps looking at the clock, the best thing would be if I
Yeah,
coordinated
if
that
you
and-
think about it, and if you felt like writing a page on the subject, that would be helpful for
Only a page.
all of us.
Only a page, yes.
Yes, I said a page, not 42 pages as your skeleton, I think. 40, sorry.
I was going to say, my lord, ours was within the limit that my lord gave. Others were not, so I would not take any criticism.
Ours wasn't, and
Yeah.
we didn't do the Garamond trick.
No, and it was like, yeah, we did
Enough,
do that one.
enough. Thank you both very much. We'll see you in the morning at, I think, 10 o'clock.
10 o'clock.